I'm Stephen Koprince, Managing Partner of Koprince Law LLC. And today I'm talking about an important SBA case in which an 8A Mentor-Protege joint venture was found not to qualify for a service-disabled, veteran-owned small business set-aside contract. Because, and this is important, the OHA held that this joint venture was not comprised of two small businesses. In a recent decision, the SBA Office of Hearings and Appeals held that an SDVOSB-specific regulation requires all members of an SDVOSB joint venture to be small, notwithstanding specific language in the SBA's size regulations and 8A program regulations specifying that an SBA-approved Mentor-Protege joint venture may bid as a small business on any government contract or subcontract, provided that the protege is small. Now, OHA's decision is called EKCG LLC. If you want to look that up for yourself, it's on the SBA's website, the docket number, SBA number, VET 255. And this case involved a Department of Justice solicitation for information security services. It was set aside as an SDVOSB contract. After evaluating proposals, the DOJ announced that EKCG LLC had been selected for award. An unsuccessful competitor subsequently filed an SDVOSB status protest against EKCG. The competitor stated that EKCG was a joint venture between Aspire Services LLC and Knowledge Consulting Group, Inc. The competitor contended that because KCG Knowledge was an acknowledged large business, the EKCG joint venture didn't comply with the SBA's SDVOSB joint venture regulations, which require both parties to the joint venture to be small businesses. Now, EKCG, the joint venture, responded to the protest. EKCG argued that Aspire and KCG were parties to an SBA-approved 8A Mentor-Protege relationship. In other words, the protege firm here is both 8A and SDVOSB. EKCG then said, Mentor-Protege joint ventures are eligible to bid as a small business on any federal procurement, provided the protege is a small business, and that's a common understanding of how the regulations work. But the SBA's Director of Government Contracting held that under the SDVOSB program's regulations, which are found in 13 CFR Part 125, all parties to an SDVOSB joint venture must be small businesses, even if one of those parties is a large SBA-approved 8A mentor. The Director of Government Contracting rejected the argument that EKCG's status as an approved 8A Mentor-Protege joint venture exempted it from the requirement. And so the Director of Government Contracting issued a decision finding EKCG to be ineligible for award of the Department of Justice SDVOSB set-aside contract. Well, EKCG filed an appeal with OHA. EKCG argued in part that the SBA's size and 8A program regulations, which are specifically found in 13 CFR 121-103 and 13 CFR 124-520, permit a mentor and protege to joint venture as a small business for any procurement, so long as the protege qualifies as a small business. And that is pretty much what the regulations say. EKCG argued that it was contrary to these regulations for the SBA's Director of Government Contracting to insist that an SDVOSB joint venture be comprised exclusively of small businesses in a case where the joint venture is an SBA-approved 8A Mentor-Protege joint venture. But OHA disagreed with this argument. OHA wrote that a close reading of the regulations demonstrates, and this I'm quoting here, demonstrates that the regulations grant Mentor-Protege joint ventures an exception to affiliation for size purposes, but do not indicate that a mentor and protege are also exempt from other program-specific requirements. OHA continued that neither of the regulations, and I'm quoting again, states that mentor-protege joint ventures are exempt from program-specific requirements if the mentor and protege choose to compete for procurements under such programs. Similarly, there is no indication in the SDVO joint venture regulation itself, or in the corresponding regulations pertaining to hub zone joint ventures and WSB joint ventures, that the rules are not applicable to mentor-protege joint ventures. I therefore find no basis to conclude that a mentor and protege are excused from program-specific regulations, in addition to enjoying an exemption from affiliation. So OHA affirmed the DCG's Director of Government Contracting's SDVOSB determination and denied the appeal. Now, in my view, the small business requirements, the SDVOSB small business requirements in 13 CFR Part 125 should be viewed through the lens of the SBA's size regulations, the ones in 13 CFR Part 121, which is where a small business is defined. Now, those size regulations provide that an 8A Mentor-Protege joint venture, and here I'm going to quote specifically, may bid as a small business for any federal government prime contractor subcontract provided the protege qualifies as a small business. On top of that, 13 CFR 121-103H specifically discusses that special mentor-protege rule in the context of non-8A contracts, using the phrase, e.g. small business set-aside or hub zone set-aside, suggesting that the SBA's rulemakers, the folks who drafted this regulation, intended this mentor-protege exception to apply to mentor-protege joint ventures competing under socioeconomic programs like the hub zone program and like the SDVOSB program here. So while OHA's decision isn't necessarily unreasonable, I don't think it's the best reading of the regulations or the best interpretation of the intent of the SBA's rulemakers. Of course, my view isn't what counts, unless and until EKCG decision is reversed. 8A mentor-protege joint venture should stand forewarned. If the mentor is a large business, the joint venture likely is ineligible for an SDVOSB set-aside contract.